This afternoon, the long-awaited decision of the Chief Justice in relation to the preliminary objections made in respect of petitions number 88 and 99 were delivered by the Chief Justice this afternoon. I must say, firstly, that the decision of the Chief Justice in relation to petition number 99 will certainly be appealed because we are of the opinion that the decision is incorrect, with the greatest of respect to the Chief Justice. The decision made by the Chief Justice in relation to petition number 99 centers around the alleged failure to effect service on Mr. Granger within the time frame required by the rules made under and in respect of the National Assembly Validity of Election Act, Chapter 104. There was before the Chief Justice affidavit evidence which indicates conclusively that Mr. David Granger was served with all the documents as required by law. The Chief Justice, in her opinion, came to the conclusion, firstly, that the initial documents filed indicated that Mr. Granger was not served in time. Secondly, she came to the conclusion that leave was required by the petitioner's lawyers to file a supplementary affidavit to indicate the true date and time of service on Mr. Granger. And thirdly, because leave was required, it follows in her opinion and according to that line of reasoning pursued by the learned Chief Justice, that the failure to file a supplementary affidavit without leave meant that before the court, there was no affidavit service before the court. And the affidavit filed did not indicate when Mr. Granger would have been served in compliance with Section 9.5 of the National Assembly Validity of Election Laws. And if the Chief Justice had regard to the affidavit, that it was filled with material inconsistencies. These propositions, we respectfully say, are not reflective of the true state of affairs, firstly, in fact, and secondly, the true state of affairs in terms of what is required by the law. The National Assembly Validity of Election Act does not provide any timelines for the filing of an affidavit of service or even a supplementary affidavit of service. The section of the rule simply provides that the affidavit must be filed as soon as reasonably practicable. The error in the original affidavit meant that the supplementary affidavit was filed in less than 3 months between the time of the initial service on Mr. Granger and the time when the supplementary affidavit was served. So at the time the Chief Justice was delivering her decision, there was an affidavit before her of service. The question then turns on whether it was filed within a reasonable time. The Chief Justice herself pointed out that the previous decisions of the High Court of Guyana indicated that there were extraordinarily and inordinate long delays, which would have attended the court coming to the conclusion in previous cases that there would have been a delay in filing an affidavit of service. We filed the supplementary affidavit, which meant that there would have been affidavit evidence of service in respect of Mr. Granger within the period of 3 months. We find that the conclusion made by the Chief Justice that in fact there was no affidavit of service or that it was filed in an inordinately long time as not reflective of the jurisprudence that existed prior to this case or in respect of the decisions made in other Commonwealth countries. So we are at a point where an important decision has been made by the court in respect of an important case that reflects the polity of this country has been made by the court, and we strenuously disagree with it. We will be filing an appeal to the court, and we expect that appeal will be heard expeditiously, and that this incorrect decision made by the court will be corrected by appeal. Now, the Chief Justice, whilst dismissing petition number 99, in respect of petition number 88, ruled that that is a valid and proper petition to be heard before the court. The Chief Justice indicated that a certain number of days were fixed in respect of the 12th of February. Counsel for the petitioners will have to file submissions by the 12th of February 2021. The respondents will have to file submissions and reply by the 5th of March, and we will have to file a reply if necessary by the 19th of March.